The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to our webinar. This is Wolfsdorf Immigration Law Group. I am Sarah Baker and I'm joined by my colleague Jessica Marks. Today we'll be talking about visa options for physicians, specifically J-1 waivers and paths to permanent residence. You can see our emails listed on this first slide just down by the bottom right corner. We're going to ask that attendees hold their questions until the end of the webinar. We'll have a question and answer session through the GoToWebinar portal. You'll be able to type your questions into the box that probably appears in the top right corner of your computer screen. And we're also happy to let you know about another webinar we have coming up for F1 students. If you have any friends or family who need information about F1 visas, we'll be presenting on that subject, some of our other colleagues, on November 8th at the same time of day. All right, so we are going to delve into the webinar, and as you can see, we'll be talking about three main topics: J-1 waiver options for physicians, fulfilling the terms of the 2-year home residence requirements, and then pathways to obtaining a green card for physicians. Here we're going to talk specifically about perm labor certification, which involves an employer testing the labor market, and the national interest waiver for physicians. It's a clinical waiver. And I'm going to turn the slides over to my colleague, Jessica, who will start us off with some general information about J-1 visas.
Thanks, Sarah. So as Sarah said, we're going to go ahead and just get down to some basics here. With the J-1 physicians, you're all going to have to worry about this 2-year home residence requirement. Most of you are going to be familiar with what it is, but we're going to touch briefly on what the 2-year home residence requirement is, how to determine if you are subject, and what to do if you're subject. So jumping right in, let's cover what the 2-year home residence requirement entails. This is also referred to as Section 212E of the Immigration and Nationality Act. This law mandates that a J-1 physician or any other exchange visitor who's subject to 212E must return home to the country of nationality or last permanent residence for an aggregate of 2 years before being eligible to receive an H or L visa or permanent residence in the United States. If you are subject, you are ineligible to change status to another non-immigrant status without having a waiver or having already complied with the 2 years. And the only exception is a diplomatic and G, international or non-governmental organization status. So that really doesn't leave a whole lot of options. However, you are eligible to apply for a visa at a consulate or embassy abroad for the rest of the non-immigrant visa alphabet, and that includes J2, O1, TN, F1, E1, E2, E3, but again, you must apply for them abroad. You are not eligible for a change of status from within the U.S., nor are you eligible for a green card. How to determine if you are a subject. If you are here as an ECFMG-sponsored physician undertaking graduate medical education, you are absolutely subject to the 2-year home residence requirement. With the visa holders as exchange visitors who are pursuing research sponsored by either the U.S. government or the home country government or an international organization that is funding your stay here in the U.S. for the purpose of promoting cultural exchange, Fulbrights are the classic example, you're also going to be subject to the 2-year home residence requirement. Then there's also something known as the skills list. This dates back decades and decades, and it's basically other countries, your home country, telling the United States what skills are in short supply and high demand, and anyone who comes to the United States to participate in an exchange program that is relevant to one of the skills listed on the skills list for their home country is going to be subject to the 2-year home residence requirement. For any of you J2s or any of you J1s that have a J2 spouse or child dependent, that dependent is also going to be subject to the 2-year home residence requirement if the J1 is subject. And something important to note about that is that the rules in this arena have become more and more restrictive over the decades, such that now if the J1 goes home to comply with the 2 years, but the J2 does not, the J2 remains independently subject. The J1 complying does not transfer to the J2. However, if a J1 receives a waiver and the J2 is listed on the waiver application, then that waiver will cover the J2. What to do if you're subject? You basically have 2 choices. I don't want to offend anyone or make it sound as though we think that you have a very serious problem, although in a sense you do. But I generally characterize the 2-year home residence requirement as a disease. Once you enter the U.S. on your J-subject visa or change status to J status and you are subject, you are infected. There is no way to be cured other than fulfilling the 2 years or a waiver. For some reason, a lot of people who are subject and then marry a U.S. citizen, they have this idea in their head that, oh, I'm safe now. I have my lovely U.S. citizen husband or wife, and I have no problem any longer. No, you're still infected. Until you get the cure, there's no green card, there's no H visa, there's no L. So fulfilling the requirement, you look at your Form DS 2019, or if you've been here for a very long time or came here a long time ago on your J, your Form IAP 66, and that will tell you what your country of return is. If you reside and are physically present in that country for an aggregate of 2 years after your J program concludes, then you have fulfilled and you can get your green card, you can get your H or your L visa. You can obtain another non-immigrant status by applying for the visa abroad or changing status to A or G within the U.S. And in that regard, you can work or study or whatever it is that you're seeking to do in the U.S. But again, the 2-year home residence requirement has not gone anywhere. You still have to comply or apply for a waiver in order to ultimately immigrate to the U.S. as a lawful permanent resident. And then finally there, the third option, of course, is applying for that waiver. So I'm going to turn the microphone back over to Sarah here, and she's going to discuss a little bit more about how to fulfill the 2-year home residence requirement.
Thanks, Jessica. Okay, so you've been infected with this terrible J1 subject visa, and you are wanting to know what the heck you can do to either cure or get a waiver. Excuse me. So as Jessica said, your aggregate 2-year period must be spent in your J1 country of nationality or country of last permanent residence. So you're looking at your Form DS 2019 for that information. If you became a citizen of another country while you were in J1 status in the U.S., you still have to return to the original country of nationality or last permanent residence. The newly acquired citizenship that you have is not really relevant for the purposes of going home for this 2-year period. As Jessica said, you can fill the requirement in increments. For example, perhaps you are eligible for some other non-immigrant visa as you finish your J1 program, maybe an O. You get on your O1 visa for individuals of extraordinary ability, and then you spend your summers in your home country. Well, after you spend 24 months of summers in your home country, you'll have accrued that 2 years of time in your home country, and you will have fulfilled the 2-year home residence requirement. If that is something you choose to do, keep in mind that it's going to take a long time, and you also need to keep extremely good records of all your trips home, all your time spent in your home country for those summers, for example, plane tickets, travel itineraries, rental car receipts, stamps in your passport. so that if you later decide to become a permanent resident, you can document the full 2 years was spent in your home country.
Sarah, can I just mention something in that regard real quick? Okay, so this is a slightly esoteric point that is not going to apply to most people, but I think that I have heard, I've personally never experienced this, but I have heard of some colleagues who at the adjustment of status green card stage have seen U.S. Citizenship and Immigration Services, which is the agency that adjudicates green card applications, make a big point about the language in 212E of the Immigration and Nationality Act about the portion of the statute that says reside, because it's not just being physically present in the country of return, but you have to reside and be physically present in.
That's right.
So a lot of the requests for evidence that I've heard about in this regard really focus on whether you were actually maintaining a residence in your home country. So if you were trying to cobble together that aggregate of 2 years over 5, 10, 15, 20 years of being in the U.S. on an O1 or something of that nature, immigration could, if they wanted to, make a big deal about the fact that, well, you were physically present in the home country for an aggregate of 2 years, you are not actually residing there.
Yeah, that's a really, really good point, and it all kind of goes under making sure your I's are dotted and your T's are crossed if you're going to follow this route of accruing in the aggregate your 24 months back home. We also get questions from individuals who are passport holder citizens of EU countries. They wonder if they can go back home to another EU country than the one that is on their DS 2019 form for the 2-year period and fulfill the home residence requirement in that third country, if you will. Unfortunately, even though you may be in an EU country and you get this great job opportunity after your J1 program ends, but it's not your home country, going back there, residing there in that third country will not work for fulfilling the home residence requirement just by virtue of the fact that this is another EU country. You have to go back to the country that is listed appropriately on your DS 2019 form. Okay, so next we're going to talk about options in terms of postponing the 2-year home residence requirement. So a J1 physician can depart the U.S. and obtain another non-immigrant status if he or she is otherwise eligible, and that status can include a J2, which, as Jessica said, is the dependent spouse or child visa of J1 principals. The O1 is for individuals of extraordinary ability. Often those are doctors who are pursuing research in addition to clinical duties. The TN visa is for Mexican and Canadian citizens who get a job opportunity in a list of professions that is in an appendix to the NAFTA Free Trade Agreement. There's a set list of professions that would qualify you for a TN professional visa. F1 is a student visa. E1 is for treaty traders. They're people from countries who have a trade agreement with the United States. And then similarly, the E2 investor visa is for people who have agreements also with the United States where they'll come invest money, start a business here in the U.S. And you have, lastly, the E3, which is sort of like an H-1B professional visa for specifically Australian nationals. So as a reminder, even though you have this infection, getting this other type of non-immigrant status will not cure it. It just postpones you having to either go home for your 2 years or get a waiver of the home residence requirement. And you cannot apply for permanent residence until you've either complied with the home residence rule or obtained a waiver. As Jessica said, there are no exceptions to this, including marrying a U.S. citizen, for example. All right, so I'm going to turn the presentation back over to Jessica, and she is going to start us off by talking in general about the various J-1 waiver options.
Thanks, Sarah. So if you look on your screen there, you see 4 options. There's 4 pathways to a J-1 waiver. The first is a no objection letter. This generally applies in cases where the foreign national J-1 is subject based on the skills list. There is the persecution waiver, which is similar to applying for a grant of asylum. There is the exceptional hardship waiver for J-1s who have a qualifying relative. That has to be a U.S. citizen or green card holder, spouse, or child. And then there's the interested government agency, which is, I would say, probably the majority of J-1 physicians pursue this option, and it's based on a request from a state public health department or federal equivalent, such as the Veterans Affairs or the Delta Regional Authority, for example. It only applies to foreign medical graduates, this type of interested government agency waiver. And in recognition of Senator Conrad from North Dakota, who's been the champion of this legislation for many, many years, the state version is generally called a Conrad State 30 J-1 waiver. So the no objection letter, if you're a J-1 physician, ECFMG sponsored, you can just tune out at this point because it does not apply to you. You only have those other 3 options for a J-1 waiver. You cannot apply for a waiver based on a no objection letter from your home country. For those of you who received U.S. government funding through Fulbright or some other kind of scholarship, unless the Fulbright Commission in the home country occurs, and even in those cases, trying to obtain a waiver as a current or former Fulbright based on a no objection letter is not impossible, but very close. This is probably, it's, again, if the 2-year home residence requirement is a disease or infection, then Fulbrights are generally stage 4. So the application for no objection letter is submitted directly to the home country's embassy in D.C., or you can contact your consulate at the major city that's closest to you and find out more about the procedure. The release is from the home country's organization that sponsored the training or work in the U.S. if you also received funding from your home country. And the kind of documentation that they require, how willing they are to assist, really is all over the map. You need to know what your country's specific requirements are, and really the best way to do that is to pick up the phone and speak with someone. And these policies also change over time. Some countries, if they feel that too many people are immigrating to the United States, they may get tougher on their requirements for doing a no objection letter. So just because maybe your friend got a waiver through this pathway 5 years ago doesn't necessarily mean that it's going to still be available to you. Some consulates and embassies also have good information on their website, but if this is a pathway to a waiver that you're thinking about pursuing, we definitely recommend picking up that phone and calling your embassy or consulate. The persecution waiver, as I said, is similar to a grant of asylum, except that there is only 3 bases on which you can apply, and that is race, religion, or political opinion. There is no membership in a particular social group, and this is based on a fear of persecution if you return to the home country in which you are required to spend 2 years. This requires substantial documentary evidence of persecution. One area that we're hearing about this being quite successful the past, I would say, few months or years is in Pakistan, where some Shia physicians have established that they are being persecuted in the home country, and the Department of State, our understanding, has been very cognizant of that. So that's just one example of a successful type of persecution waiver. If you're going to be pursuing this based on some kind of religious grounds, then definitely check out the Department of State's religious freedom reports that they issue annually. And then the Department of State also has country condition reports, human rights reports. There's a lot of good information that Department of State itself publishes in this regard. The third waiver option is through exceptional hardship. Again, you only qualify for this type of waiver if you have a U.S. citizen or lawful permanent resident spouse or child. In this regard, generally the more qualifying relatives you have, the better, because you can demonstrate a higher level of hardship. The hardship to you as the J1 physician is not considered unless you can successfully argue that that hardship you will experience is somehow going to create an indirect hardship that is exceptional to the qualifying relative. This is actually a two-pronged test because you must show that your qualifying spouse or child will experience exceptional hardship both if they remain in the U.S. without you, will you go to the home country to fulfill for 2 years, and the exceptional hardship would result to the spouse and or child if they accompany you to the home country for at least 2 years. So types of hardship that are most compelling are generally going to be medical. If the qualifying spouse and or child has a serious medical condition, a psychological condition, simply just saying, I'm really going to miss my baby if I don't get to see her for 2 years, that unfortunately has not been recognized as exceptional hardship. It has to be hardship above and beyond what we would normally expect people to experience from being separated for a period of 2 years. This waiver can technically be filed at any time during your graduate medical training. Sarah's going to touch more briefly on the kind of time frame for filing an interested government agency waiver, but because those are based on the fiscal year, you can really only apply the year before your training is scheduled to end. However, I say this with the caveat now that the timing of the hardship waiver is becoming more important because the Waiver Review Division of Department of State said, I believe it was about a year ago now, that if you apply for a waiver and then are subsequently issued new DS 2019s to participate in the program that has made you subject, that the waiver is not going to cover that subsequent time spent as a J1 exchange visitor. This is pretty controversial and a departure from practices that I think have gone on, for decades, where Department of State has never taken that position. But if you are applying for a hardship waiver and expect to be in your program for several more years, that's something that you would want to discuss with your immigration counsel. If the waiver is granted, then you can file for permanent residence immediately. If you are applying based on hardship to a U.S. citizen spouse, or you have a U.S. citizen spouse, then that spouse can immediately file an I-130 petition for alien relative on your behalf, and you can simultaneously file an I-485 green card application and continue on your pathway to permanent residence in that way. If the application is not successful for the hardship waiver, you can still apply for an interested government agency waiver. Having the denied waiver on your record with Department of State does not prejudice a future application under a different pathway or even the same pathway, because an exceptional hardship waiver, if denied, is one of the types of waivers that Department of State allows you to apply again in the future because they recognize that the hardship conditions can change over time. One thing we really want to point out and make sure everyone understands is that the waiver itself does not provide any kind of underlying non-immigrant status. If you can't apply immediately for permanent residence after getting the waiver because, for example, your spouse is only a lawful permanent resident and not a U.S. citizen, so you have a couple of years to wait in the green card waiting line, then you need to think about securing an H-1B or other non-immigrant visa while you are waiting for your turn in the green card waiting line to come. Something else we want to point out is that the hardship waiver, if granted, does not mean that you can now change status in the United States. The Conrad waiver, as Sarah is going to explain, does permit that, but a persecution waiver, a hardship waiver, there is still that bar to applying for a change of status from, for example, J1 to H1B. So if you do get this waiver and are not able to apply for the green card right away, you're going to have to travel to get the visa stamp for whatever non-immigrant status you're pursuing. So now I'm going to hand things back over to Sarah, and she's going to take us through the different types of IGA waivers for physicians.
Thank you. All right, so on your screen you see a variety of interested government agencies that will act as entities adjudicating J1 waivers. So the Conrad 30 state program is a type of waiver where the health department of each state is able to review your waiver application, and then you'll be working for 3 years in a medically underserved area. The Veterans Administration also sponsors waivers for physicians to work in Veterans Administration facilities. There are 2 entities that exist in the U.S. that promote certain regional interests for various parts of the country. The first is the Appalachian Regional Commission. So they promote the interests of Appalachia, which includes parts of Alabama, Georgia, Kentucky, Maryland, Mississippi, New York, North Carolina, Ohio, Pennsylvania, South Carolina, Tennessee, Virginia, and West Virginia. And they provide a means of having a waiver reviewed to work in an underserved area in a region within those states that I just named that's underserved and considered to be part of Appalachia. And the second entity that promotes regional interests in the U.S. is the Delta Regional Authority. They will look at waivers for physicians to practice in underserved areas in parts of Alabama, Arkansas, Illinois, Kentucky, Louisiana, Mississippi, Missouri, and Tennessee. The Department of Health and Human Services will also review 2 types of waivers. One is a clinical waiver based on service in a medically underserved community, and the other is based on research performed in an area of high priority or significant interest to the Department of Health and Human Services, and by extension, it's in the interest of the United States. So some general tips on the IGA J1 waiver program. Any federal agency or state Department of Health can act as an IGA. The Department of Agriculture, Department of Education, and now Department of Commerce, however, will no longer act as interested government agencies for the purposes of waiver applications. So the first type of waiver program that we're going to talk about, IGA waiver program, is the Conrad State 30 waiver program. We recently published a blog on this topic on our blog website. The website is listed there on the screen for you. You can also connect to our blog. It's called Wolfsdorf Connect. If you go to our website, and there is a heading towards the right of the page, top of the page, for the link to our blog. And we have a more detailed publication, a practical guide to State 30 J1 waiver programs that's also available under the Publications tab on our website. All states in the United States have a program. The Health Department serves as the interested government agency, and that interested government agency can issue up to 30 waivers per fiscal year. So typically, the fiscal year you're looking at will be October 1st to September 30th, following the federal fiscal year, but this can vary depending on the state in which you're applying. For example, Texas began accepting waiver applications on September 5th after the Labor Day holiday. And waivers are usually processed on a first-come, first-served basis once they're filed with the state health agency, but some states choose to prioritize the waiver applications based on need. That is, what type of physicians they have the most need for in their state and its underserved areas, or they'll be looking at the merits of the entire application as a whole instead of just processing on a first-come, first-served basis. So for Conrad State 30 waiver programs, most states require that you be working in a job that's located in a health professional shortage area or medically underserved area, or serving a medically underserved population. These are designations that are made by the federal government, and they're published in the Federal Register. You can also look up the address of the clinic where you're going to be working and see if it's in a HPSA, MUA, or MUP online, and the website for that is http://hipsafind.hrsa.gov. You can Google HPSA and you'll get that information too. There are also mental health HPSAs for psychiatrists who are considering Conrad 30 J1 waivers. Many states allow up to 10 what we call flex slots for jobs that are not located in a HPSA, MUA, or MUP. The physician still has to serve an underserved population, and what you show for this type of waiver is that the patient population is coming from a HPSA, MUA, or MUP, even though the clinic itself is not located in one of those designated areas. The job can be in a rural or urban site. For example, let's say you find a position in Los Angeles. There are plenty of urban locations in Los Angeles that are underserved. It's not just rural locations where we need these doctors. So generally, the first step in a Conrad 30 waiver application is always to apply for a case number with the U.S. Department of State. The fee for doing so is $215, and you will get a case number which allows you to track your waiver application while it is with Department of State, which will be the second agency that will review the Conrad 30 application after the state health agency. Your application is initially submitted directly to the state health department, and it's important that you check with your state health department what the specific guidelines are for them accepting applications. Each state has general requirements that will apply for all states, and some have more specific requirements that are unique to the particular state in which you're applying. Some states also have filing fees. For example, there's a non-refundable filing fee in Ohio of a whopping $3,571 for them to accept and process your J1 waiver application. Texas, for example, has a fee of $2,500. So this is generally in addition to legal fees. For example, if you have an attorney assist you in preparing the waiver application. However, not all states charge a fee just to file the waiver application. So there's a heavy focus in these Conrad 30 waivers on supporting primary care physicians. You have to check with the state you're interested in applying in if they accept only applications from primary care doctors, or if they will allow specialists to apply as well. Often states that do accept specialists will put a certain number of applications aside for specialists, but then that's it. They'll cap it off at maybe 3, 5, whatever the number of specialist applications is that they'll accept. And you also have to look out for states that will not accept applications for primary medical care from doctors who have specialist training. Some states are very concerned that you'll have a doctor with specialist training come in and apply for a waiver as a primary care physician, get to the practice site, and then actually be conducting specialty care medicine, and they don't want that. They're interested, again, in promoting primary care medicine and making it available to patients. A recent example I came across was with California. If you look on their J1 waiver website, they say that in order to be eligible, you have to have completed a U.S. residency training program in family medicine, general pediatrics, general OB or gynecology, general internal medicine, general psychiatry, with no subsequent specialty training. So this was new language to me, so I contacted the California Department of Health to inquire whether it was really the case that they would not accept applications from individuals who have subsequent specialty training, and that they said that they would. They're still reviewing this language on their website, as long as the doctor was, in fact, really coming to do a primary care position. And as things stand, as of October 12, 2012, California had received 8 waiver applications. So that may be something to watch for in California in the future, what their stance is on accepting waiver applications from specialist doctors who are going to be doing primary care. So you have to have an employment contract as part of the Conrad State 30 waiver application. The basic requirements are that it be for 3 years of employment, 40 hours per week, working in your underserved area or your flex location. Some states will not allow the contract to have a non-compete clause in the, they want you to be able to continue working in that underserved area, let's say if you had to move to another employer after your 3-year period was up. Some states do require a service term of more than 3 years. They'll tack on 1 or 2 more years before they're willing to issue a letter saying that you've complied with the terms of the waiver. There are recruitment requirements for this type of J1 waiver application, and these can vary from state to state. For example, some states go back and look 6 months prior to submission of the waiver application to see what recruitment was completed. Some want to go back a year prior. It just really depends. You also have to show, as part of the documentation submitted with your waiver, that there's a shortage of physicians in the area, in the particular practice area that you'll be practicing in. And one good thing about this type of waiver is that J1 waiver physicians who get a waiver and then need to switch to H-1B status to fulfill their 3-year service period are exempt. Their H-1B applications are exempt from the annual cap, which is imposed on H-1B petitions. So they're also allowed to change status in the United States from J1 to H-1B instead of having to depart the U.S., get a visa at a consulate, and then enter in that new H-1B status. So that's a nice advantage for those J1 waiver physicians. You can hold part-time employment with another employer while you're working for your J1 waiver employer. You need to check with your state, though, to see if they don't mind that you do this. And H-1B petitions are employer-specific. So you would have to file a second H-1B petition if you're going to be working for employer B part-time, maybe moonlighting, in addition to working for your J1 waiver employer. You must be an employee, and you cannot be an independent contractor. There's a heavy preference for employees in this type of waiver application. And you must fill your 3 years of employment at the locations listed on the petition. So when you're crafting your application with your attorney, you need to be very clear up front what the worksite locations are going to be for the waiver, and make sure that they're all included in that waiver application and then listed in the H-1B filing as well. you really cannot change jobs. It's hard to change jobs from one J1 waiver employer to another unless you demonstrate that there are extenuating circumstances necessitating the change. That includes things like closure of the facility, the employer's failure to comply with terms of your J1 waiver contract, for example, or a severe family situation that requires you to move either from one area of the state to another or perhaps from one state to another. So to do this, to move and change employers, you have to file an H-1B transfer petition or an H-1B change of employer application, and that's where you're proving what the extenuating circumstances are that necessitate your move and change of employer. It's often helpful to get the support of the state health agency in filing an extenuating circumstances H-1B, but it's not necessarily required if you're not able to get that for some reason. So we're going to turn next to the Veterans Administration J1 waiver program. They will serve as an IGA and make a recommendation to Department of State, the second agency that reviews waiver applications. You don't have to worry about whether the work is going to be performed in a health professional shortage area, medically underserved area, or serving a medically underserved population. The key is that you're working at a Veterans Administration facility serving veteran patients. You also have to demonstrate that there was a shortage of that type of physician in the area through extensive recruitment. And usually this is initially handled by the VA. They have very strict internal recruitment procedures that they employ before they're willing to hire a J1 waiver physician. And the waiver application originates from one part of the VA employer, whichever VA facility you're working for, and they submit the application to sort of the central filing entity within the VA for processing and review. So some more tips about the VA waiver program. There's no primary care requirement, and you can certainly work as a specialist physician at a VA facility. Again, you have this 3-year contract requirement, and you have to be working at least 40 hours per week doing patient care at the VA. Sometimes VAs have relationships with local universities. Maybe you get a joint appointment as some kind of professor in addition to working at the VA. You must be careful, though, because 5/8 of your time must be spent working at the VA in order to meet the requirements for this type of waiver. If you're on an O1 and you're looking at getting the VA to sponsor your waiver application, you need to be careful because VA has an internal policy that they will not sponsor a waiver for an O1 visa holder unless that O1 visa holder has worked in O1 status for the VA for at least 2 years. And we've also been letting clients know recently that there can be issues with the Veterans Administration's willingness to sponsor H-1B extensions. So, for example, maybe you get a waiver with the VA and you don't begin your employment actually on the first day that the H-1B is valid. So because of that, you need to work into a second 3-year H-1B period to complete the full 3 years of service that's required for the waiver. Some VAs have been unwilling to extend the H-1B, which has left some doctors, a couple months, a few days, whatever the case may be, shy of filling that 3 years of service requirement. And then they're left having to scramble to look for another employer just to round out that time and get themselves to the 3 years of service. So we're going to turn next to the Department of Health and Human Services waiver programs. As I mentioned, there are 2 waiver programs with this agency, the Program for Clinical Care in an Underserved Area And then the program for research that's performed in an area of priority or significant interest to the Department of Health and Human Services, and then by extension, the United States. For the clinical program, you are looking at working in a location that has a HPSA score of 7 or higher. All these HPSAs that are designated by the federal government have scores to them. It's got to be 7 or higher. Either a rural or urban HPSA would qualify, and you have to get support and acknowledgement from a state health department, and you're filing your waiver application initially with Health and Human Services. In the clinical program, they will only accept primary care physicians and psychiatrists. Subspecialists are not eligible. That includes people who, maybe you only have 1 day of fellowship specialty training. You're not eligible for this program. There is a 3-year, 40-hour per week work commitment that's required, similar to the J1 waiver program. There's no non-compete clauses that are permitted in your employment contract. You have to demonstrate recruitment, and your residency must have been completed within 1 year prior to filing. Okay, we are getting short on time, so I'm going to zip through the research waiver program requirements. Again, if anybody has questions after the webinar is over, please don't hesitate to email us if we're not able to get to your questions today. So the HHS research program is for academic researchers and people engaged in translational research. The focus here is really on basic science research. They're not really looking to sponsor waivers for clinicians. However, we have been recently successful in obtaining HHS waivers for certain transplant surgeons who have a large research component to their work. There's no contract requirement, but your job has to be permanent. And you do have to show that the J1 physician cannot be replaced through recruitment. They're wanting you to go back 18 months or less in terms of demonstrating recruitment that did not lead to finding someone who could replace the J1 physician. And that includes requiring 1 journal ad in a specialty or an area that's appropriate for your practice area or your research area. So the main elements of the waiver, they're really looking at research that's of national priority and interest to HHS. For this reason, if you have NIH grant funding, this is a good way to show the link between your research and the government's interest in what you're doing. You must be essential to the program, so essential that if you left the U.S., a major part of the program or the entire thing would actually collapse and end. So here you have to talk about what the consequences of the waiver not being granted would be. And as I mentioned before, you've got to show that the J1 could not be replaced, and that is where the evidence of recruitment comes in. So I'm going to turn the slides back to Jessica, who is going to talk about processing timelines for these various IGA waivers, and then we're going to dip into permanent residence.
Thanks, Sarah. So up on the screen there, you see that the timelines really vary depending on what agency you're dealing with. And within the Conrad State 30s alone, of course, there's 50 states, and then Guam can also do waivers. So you're dealing with dozens of different time frames. A waiver can be approved by a state in a day, or it could take several weeks. So when thinking about your waiver options, it really is important to get started at the earliest possible moment, because you don't want to run into a time crunch as your program is ending and be without a waiver and without a plan for getting your H-1B or other non-immigrant visa if you're not going through the IGA process. So the IGAs, it really depends, and the times tend to vary. Obviously, toward the beginning of the fiscal year with the states is generally when they're going to be busiest. Some states always fill up, like New York and Texas, right away. So toward the beginning is going to be a bit slower, but for the states that you can just kind of trickle into throughout the fiscal year, some of them can go quite quickly because it's all depending on volume. Department of State also depends on volume. Sometimes they go very quickly. Sometimes they get a little backed up. For a while there, when things were especially busy, we were seeing them take up to 10 weeks. So the file arrives to them after the State Department of Public Health or equivalent has recommended that the waiver be approved. Then you're on to the Waiver Review Division at Department of State. Best case scenario, usually going to take about 3 to 4 weeks. Worst case scenario, sometimes up to 10 weeks. If Department of State decides to recommend that the waiver be approved, they will forward certain materials onto USCIS, which issues the final approval notice. And as you can see on the screen, that can take between 4 and 12 weeks. Sometimes we see it take as little as 2 weeks. And then once you get that final approval from USCIS, the 2-year home residence requirement is no more. You never have to think about it again, except if you're doing your 3-year commitment, then you're thinking about it every day for 3 years, because that needs to be done before you can apply for permanent residence, which is what we're going to talk about in just a few minutes. The J1 waiver, you can only file through one IGA at a time. You have to certify to whatever agency you're applying through that you don't have any other IGA waiver being considered by another agency. However, you can have a hardship waiver, for example, pending simultaneously. You don't have to pursue just one or the other. However, you should be warned that whichever application is adjudicated and recommended for approval by the Waiver Review Division of Department of State first is the one that you're stuck with. So if you're really hoping that your hardship waiver is going to go through, but you're not sure because you've heard that it's a pretty subjective standard, so you go for Conrad State 30 as a backup. If Department of State gets to the State 30 waiver first, and that is recommended by them, then you're stuck with your 3-year commitment, and the hardship waiver essentially becomes null and void. In regards to the timing for the green card, again, I mentioned that the 3-year commitment must be completed before you're eligible to apply for lawful permanent residence. But the underlying basis for the green card, which if you're applying through a relative, is the I-130 immigrant visa petition for alien relative. If you're going through an employer, a lot of the time it's going to be the perm labor certification and then the I-140 immigrant visa petition for alien worker. Those can be filed at any time while you're fulfilling the 3-year commitment. It's just that final step of applying for the actual green card, and if you're doing that within the U.S., that's the I-485 application for adjustment of status. You can do that on the 3rd year and first day after you have started your commitment. The 2 options that we're going to discuss in regards to the pathways to permanent residence is the perm labor certification and then the national interest waiver. And you can see when you compare the 2 side by side, they're really quite different. As I mentioned, the labor certification is something that is filed by the employer on your behalf. So in that sense, of course, you need to have an employer that's willing to sponsor you. Many employers who are having a tough time recruiting physicians. Obviously, it's a medically underserved area for a reason. So if you're doing a medically underserved waiver, then generally you're going to have an employer who is willing to sponsor you and keep you happy because they want to retain you in their facility and in the community beyond the 3-year period. So that's something that you should be discussing with your employer at the waiver stage. Find out what their policies are for when they are willing to sponsor their physicians through the perm labor certification process. There is a prevailing wage requirement for physicians. That's generally not a problem, but the employer must meet a prevailing wage that is determined by the Department of Labor and demonstrate that they have the ability to pay you that wage as of the date that the labor certification is filed with Department of Labor. Again, with the perm, you can apply for lawful permanent residence as soon as your 3-year commitment is fulfilled. So you can literally file the I-485 the following day, assuming that your priority date is current. And Sarah will mention in a few minutes what exactly that means, what it means to have a priority date and what it means for it to be current. With the NIW, you can self-sponsor. There's no requirement that a U.S. company file anything on your behalf. You do have to be working in an underserved area, so many physicians who are doing a State 30 or a comparable waiver are going to have a lot of the documentation and evidence already at hand because it was relevant to the J1 waiver. You can also do the NIW through a VA facility, which Sarah is also going to mention in a few minutes. There is no requirement for the prevailing wage, but there is a requirement that you work in the underserved area or at the VA facility for a 5-year period. So you're tacking on 2 years to your three-year commitment there. And you can also, again, as long as you have a current priority date, concurrently file the I-485 green card application with the immigrant visa petition. There's no requirement that you wait until your waiver period is actually over, and this can be particularly attractive to those of you that have a J2 spouse, for example, who was enjoying the work permit while on the J2, and then once they get on the H4 dependent visa, they can no longer work. The NIW allows you to file for work authorization so that your former J2 spouse can get back to work. I'm just going to touch briefly on what the process is for obtaining a green card through the perm labor certification. Again, you must have an offer of employment from a U.S. entity, and that employer must go through recruitment, extensive recruitment steps to demonstrate to the satisfaction of Department of Labor that there are no minimally qualified, able, available, and willing U.S. workers for the position that's being offered to you. Again, this generally isn't too challenging in the underserved area context because, again, it's an underserved area. They have trouble recruiting physicians to them. So most of the time, the perm is going to be a very solid option for applying for lawful permanent residence after your waiver. There is the prevailing wage requirement. This is a determination that's made by the Department of Labor. At the outset of the process, you file a prevailing wage request with DOL, and generally within 5 to 6 weeks, you have that determination back, and that wage has to be paid to you as soon as you are granted lawful permanent residence. Again, this is rarely an issue for physicians. Perm processing right now is taking just about 60 days from the date of filing. Sometimes it might take up to 3 months. The applications are filed online. They're not supported with any documentation. But if Department of Labor decides to audit your case, that means not only that you're going to have to send in the supporting documentation, or rather your employer will, to prove all of the recruitment steps that they underwent, but that is going to bump up the processing time significantly. It used to be 2 years. I believe that the process is now closer to 10 months. And again, the audit means sending in all the supporting documentation to DOL, and if any applicants applied for the position and were rejected, the employer has to explain why they were not qualified, willing, able, or available for the position being offered to you. The recruitment requirements for physicians and for any other professional position is placing a job order with the state workforce agency with jurisdiction over where you'll be performing the work, and that has to go for at least 30 days, and then the perm cannot be filed 30 days after the job order comes down. There's 2 Sunday ads in a local paper of general circulation in the area of intended employment. One can be replaced by a journal ad if it makes sense for the position. Then there's an internal posting that is posted at the work site for 10 business days, and then 3 additional methods of recruitment, which can be a job search engine, the employer's own website, recruitment through radio ads, another newspaper. There's 10 different options, and that's something that the Immigration Council on the case would go over with the excuse me, with the employer to decide what makes most sense for where the position is located. There is that requirement, again, of the prevailing wage. It doesn't have to be paid until you actually receive the green card, but the employer must demonstrate the actual ability to pay that wage at the time that the perm is filed. The perm can be filed at any time, even before employment commences. So if you're a hot shot in your residency program and you're being heavily recruited and courted, the employer can file a perm on your behalf at any time, even if you won't be working until a year or two from now when you're actually done with your training. But whatever the educational, training, and experiential requirements are for the position, you must meet them at the time of filing. So if the employer, for example, wants to say that board certification in pediatric pulmonology is required for the position, they can't file the perm on your behalf unless you are actually board certified in pediatric pulmonology. Once the perm is certified by the Department of Labor, the immigrant visa petition, which is called the Form I-140, must be filed within 180 days. Otherwise, the perm becomes worthless. Again, it can be filed by a prospective employer, so you don't have to immigrate through your waiver or H-1B employer that you're fulfilling your 3-year commitment with. Just a reminder, the actual I-485 application for adjustment of status for the green card, which is based on the perm and then the I-140, may not be filed until your 3 years of service in H-1B status is completed. And at the time that you file the adjustment application, you have to submit documentation proving that you completed those 3 years. Otherwise, they will not accept or approve your green card application. And right here we have what is called the Visa Bulletin. Some of you may be familiar with it. Others, it may look like a bunch of gibberish. So Sarah, for those who are not familiar, is going to walk us through it.
Thanks, Jessica. Okay, so anytime you file a green card application in the U.S., you basically have to get in line. And the place that you take in line is determined generally based on your priority date. So the priority date is either the date of filing the perm labor certification online through the process that Jessica just described, or the date that your I-140 immigrant visa petition is filed with the Immigration Service. So when you get your receipt notice for your I-140, or you know from your attorney that your perm has been filed, that is going to be the operative date for determining where you fall in the line for green card processing. So you need to look at this chart. This chart is called the Visa Bulletin. The first thing to do is determine which category your green card was filed under. Perm for physicians and the national interest waiver, which I will touch on in a minute, are generally second preference employment-based category green cards. So you will scroll down to the third line in the chart that says second for second preference. Then you need to look at what country you were born in to determine whether you're subject to a longer line or a shorter line. Let's say you were born in a country other than China, India, Mexico, or the Philippines, and you have this employment-based second preference green card filed already. So you're under the all chargeability areas except those listed. This is the November Visa Bulletin. It was released around October 10th. It shows a C there, which stands for current. So you are eligible to file your adjustment of status application really at any time. There's no date restriction on your country of chargeability. However, if you're from China or India, for example, just there 2 boxes to the right, if your priority date is not yet the 1st of September 2007 or before, or for India the 1st of September 2004 or before, you are not yet eligible to file that I-485 adjustment of status application until your priority date becomes current. So this visa bulletin is updated every month by the Department of State. They generally release the bulletin on about the 10th of each month prior to the month that they are releasing the bulletin for. So you can access that information on the Department of State's website. We are going to quickly talk about the national interest waiver. Jessica already touched on a lot of the main points about this waiver or green card application, and that was in the slide where we had the comparison of the perm labor certification and the national interest waiver. Just to explain what they mean by waiver, it's not another type of J-1 waiver that gets you a green card. Instead, when you're filing as a physician for a national interest waiver or NIW, you are asking the government to waive the requirement that you go through the perm labor certification process. You don't have to have an employer test the labor market for this type of green card application. Also, for that reason, you can self-petition. You don't have to have an employer sponsor. Similar to the Conrad 30 J1 waiver program, you need to have an employment contract, and you need to fulfill a certain amount of time working in an underserved area. For the NIW, it's a 5-year period. So a lot of physicians will get their Conrad 30 waivers, work for 3 years, and then tack on 2 more years. And your contract has to be dated within 6 months prior to filing NIW. You need the support of a health State Department of Health or a federal agency, basically the Veterans Administration, and that letter has to be dated within 6 months prior to filing your NIW. And you can apply for permanent residence, that is the adjustment of status application, at any time during your 5-year commitment if it's based on a national interest waiver petition. However, you can't get your green card, and that adjustment of status application cannot be finally adjudicated until your 5-year commitment period is up. All right, so we already touched on some of these points. The nice thing about the NIW is you're eliminating this labor certification requirement and any requirement that your employer, if you're going to have one, test the labor market. And the key to this green card application is that it's based on work being performed in an underserved area for the 5-year period. Let's say you get into an NIW position and somehow the location where you're working is no longer designated as an underserved area. That is okay. You can still fulfill your 5 years total there as long as the location where you're working was designated when the national interest waiver employment began. And as we said, it's a 5-year total service commitment. If you happen to have some other status, such as working on an O1 and you were in an underserved area, you can certainly count that towards your NIW. You just cannot count J1 work time in an underserved area towards your 5 years of service for the NIW. So that concludes the substantive part of our presentation. You have our contact information for the firm listed here. And I'll turn things over to Jessica just to wrap things up, and then we'll go for questions and answers if there's time.
So the first question that we have is a very good one that relates to how to find a sponsor. So again, as Sarah said, if we're not able to get to your question, we apologize. We do have our information up there on the screen. We do offer a free initial consultation, so we'd be happy to speak with you. We often have a lot of information that relates to physicians and international medical graduate and other healthcare professional issues in our newsletter and on the website. You see there's a link to the questionnaire on our website if you would like to contact us for a consultation that way. We have offices in California and New York. So the first question, as I mentioned, is how do I find a hospital or clinic who would sponsor me for a visa or a green card? So one of the great resources, if you're looking for a waiver job specifically, is called 3RNet. They have a great deal of information about different positions that qualify for J1 waivers in underserved areas all over the country. And then, of course, you can also contact the State Department of Public Health in the state where you're interested in practicing and hopefully getting a waiver job. They oftentimes work very closely with the physicians and recruiters who are in that state and need to attract and retain physicians to their areas. So, Sarah, there is a question here about doing a J1 waiver in a medically underserved area and then trying to change to a different state or underserved area within the same state. What are the criteria for doing that?
So that is the situation we talked about briefly. That's where you have to prove that there are extenuating circumstances that require you to move, and as a result, change employers, maybe from employer A in one region of the state to employer B in another region of the state, or to a wholly new state. As I mentioned, some extenuating circumstances include things like closure of the facility where you're currently working in H-1B status, such that there's no way you would be able to fulfill the terms of your waiver, that 3-year service period. You have to move to another employer so you can actually work. Sometimes employers make things very difficult for J1 physicians, and maybe they're not complying with the terms of the contract that they had signed with the physician. That can be a basis for an extenuating circumstances, H-1B, change of employer. Probably less common are family situations that are successfully argued as a basis for an extenuating circumstances, change of employer. It has to be something more than I just got married, for example, and I want to go live with my spouse in this new area because I miss him or her. There really has to be something extra compelling about your situation, family situation. Maybe someone suffers a severe illness and you're the only caregiver for that person, that would necessitate you moving to another part of the state or to another H-1B employer. It's definitely something that you want to speak with an attorney about to make sure that you have a legitimate, valid basis on which to file the extenuating circumstances H-1B petition. These are also discretionary, so it's in the discretion of the Citizenship and Immigration Services whether or not they'll grant the change of employer application based on extenuating circumstances. So you should also speak with an attorney about, the timing of leaving your current job and going on to employment with the new employer and that sort of thing as well.
That's a good point, Sarah, because with H-1B portability, you, the physician, are eligible and allowed to begin working with the new employer as soon as that entity files an H-1B petition on your behalf, and that petition is received by USCIS. And you don't have to wait until the petition is approved. But that carries with it the risk that USCIS will ultimately not grant your request for an extenuating circumstances transfer, and then you're in a really sticky position. So our next question relates to the green card lottery, the diversity lottery, and it's, do I qualify for the lottery as an international medical graduate if I have the J1 visa with the 2-year home residence requirement? So technically, yes, you are eligible to apply, and if you're selected for the lottery, then that's great, but you can't ultimately apply for adjustment of status or the immigrant visa abroad unless and until you get the waiver or have fulfilled the 2 years. So submitting your application for the lottery doesn't really get you very far because you're not ultimately going to be able to immigrate based on winning the lottery unless and until you have complied or received the waiver.
I would say, too, the other thing you want to watch out for is immigrant intent. You know, if you're in the middle of your J1 program and you have several years left and you know that you're going to need to extend your J1, go get visa stamps at the consulate, but you've submitted this lottery application, which is a form of a green card, you know, permanent residence application. If that's on your record, there's a chance that the consul could see that and say, well, you know, are you really intending to be here temporarily on your J1, or because of your green card lottery submission, you know, do you really have this permanent intention to reside in the United States? So you need to watch on the timing of submitting that application. This is all aside from what, you know, whether or not you have this home residence requirement as well.
Absolutely. And Sarah, we have another question here, one that we get a lot, and that is, once I have gotten my green card, do I have to stay with my employer who sponsored me for that permanent residence?
That is a great question. We do get it a lot. Of course, especially if you're working in an underserved area, you know, that employer is likely going to want to keep you there because they are underserved for a reason. They haven't been able to recruit people into that position. And you do have to show, as part of the Conrad 30 J1 waiver application, what the long-range plans the employer has for you to stay in that underserved area and continue working there. You have to be careful, you know, if you get your green card based on employer sponsorship and then a day after you decide to switch to a different employer, let's say you're applying for permanent U.S. citizenship down the road. The Immigration Service might come back and look at how soon after you got your green card you wanted to switch to employer B. And if the date from when you got your green card to when you switched to employer B who sponsored your green card is very close, the Immigration Service could come back and say, you know, we are prepared to revoke your green card application because it was clear from the beginning that you never intended to work long-term for this employer that sponsored your green card application. So you need to watch out for timing on that. And again, each case is different. I would speak to an attorney about how long they think you should be employed with that green card employer before switching to another employer.
Yeah, I believe, like with extenuating circumstances, the regulations are not very precise on this point. The regulations, I believe, say that you should be with your sponsoring employer for a reasonable period of time after having received the green card. And, of course, what's reasonable to one immigration examiner may be unreasonable to another. So it's really all about who you're dealing with. And as Sarah said, this generally comes up primarily in the context of citizenship. So we have another question here about wanting to do a fellowship after the residency training is completed. And this generally gets you in a bit of a time crunch if your residency training is going to be 7 years or longer, because the J1 gets very difficult to extend beyond 7 years. You have to go back to your home country and get these additional statements of need. And obviously, the more the home country is saying that they need you, the more difficult it can be to apply for a waiver that would allow you to remain in the U.S. rather than going back to your home country. So what we generally see is the physician completing their residency training, getting the J1 waiver, doing their 3 years in the underserved area, and then going back to do their fellowship. Because once you've used up all of your time on the J, then you can't switch to an H to complete your fellowship training because you need to be a practicing physician serving patients in an underserved area. It's not for purposes of continuing your training. So you can't get a waiver to do your fellowship. You're going to have to actually be a practicing physician in an underserved area. And then once you've completed your 3 years, you can go back and do continued graduate medical education on the H-1B. If you're a real rock star, which you may be after doing 7 or 8 years of residency on the J, you could try to get an O1 in order to do a fellowship, but that's not necessarily easy because the standard is having risen to the very top of your field of endeavor, and generally people who are still pursuing education are not at the top of their field. They're still ascending. They're certainly not impossible. We have had success with those types of clinical training O1s before, but what is being approved by USCIS today is, of course, not a guarantee for what's going to be approved in the future. So, Sarah, we have another question here about payment of the fees, and some employers not wanting to pay for the filing fees and the legal fees, and if you're going to a state that charges J1 waiver fees, and when can the physician pay, what can they pay for, what can't they pay for?
This is a really good question because we've seen some movement on this issue lately. Certainly for H-1Bs, for example, there are certain parts of the filing fees that the J1 physician is not allowed to pay for. Also, you know, if the J1 pays for part of the legal fees, for example, you have to watch and make sure that that contribution towards the legal fees does not drop the wage that the physician is going to receive below whatever the prevailing wage or the minimum wage is for that position in the area where the job will be. Now, for the J1, if you want to be, the waiver that is, if you want to be very conservative and sort of follow the line of reasoning that the government has applied with the H-1B, that there are certain things that the employer has to pay for, it would be probably a good idea and a conservative stance to take to have the employer pay the legal fees for the J1 waiver application. You know, attorneys will differ on their opinion about that. There's nothing in the regs, the regulations, or the statute that says employer has to pay for the J1 waiver legal fees, for example. So that's something you can negotiate with the employer, but definitely a more conservative stance would be for the employer to pay the fees associated with the waiver, and then those parts they're required to pay for the H-1B. But generally it's going to be something that you work out between you and the employer for the waiver.
So we have another question here slightly related to a hardship waiver. Receiving the hardship waiver on the basis of hardship to the U.S. citizen child, and then the former J1 and J2 now working on H-1Bs, how to go about getting for a green card, and does the fact that the former J1 was granted the hardship waiver mean anything for that process? And unfortunately, no, it doesn't. It's not relevant to the green card. They're two completely separate processes. It's just that having the hardship waiver allows you to apply for lawful permanent residence. The process varies. Again, a lot of it has to do with where you're born, whether you are doing it through an NIW, in which case, of course, you have to do the full 5 years, or you have an employer to sponsor you. If you have an employer who's going to do the permanent labor certification process for you, then there's at least 2 to 3 months for the perm to be processed, assuming that there's no audit. Then once that is certified, the immigrant visa petition with USCIS is going to take at least 4 to 5 months, and then the green card application itself, the I-485, can sometimes take between 6 months to 9 months, especially because at that stage they're doing a lot of criminal background checks, national security checks. So depending on where you're born and how common your name is, there's name checks, things of that nature. The process generally takes at least about a year from start to finish, and that's assuming that there's no visa bulletin, quota backlogs, or anything of that nature. So if you're doing the NIW, this physician who asked this question is currently a fellow, there are some states that will issue an NIW support letter if you are doing your training in an underserved area on an H-1B, but that depends because some states are opposed to doing an NIW if you're not yet out of your training. New York, for example, is one that doesn't allow for that. But if you are in a state that will issue an NIW support letter and you happen to be doing your training on an H-1B in an underserved area, then you could consider moving forward with an NIW right now. So I think that pretty much wraps up our presentation. We're at 10 to the hour. And like I said, we apologize if we didn't make it to your question, but we do have that online questionnaire that you can submit for a consultation, or you can feel free to contact Sarah or me directly, and we will be happy to provide you with some specific guidance about your particular case and questions. So thanks again for joining us, and we look forward to webinaring with you again soon.